कि मेरे खिलाफ कोई चार्ज फ्रेम हुआ, स्टेटमेंट ऑफ एलिगेशन दी गई जिसका मैंने जवाब देना था। नथिंग ऑफ दैट सर।
आपको कोई शो कॉज नोटिस नहीं वो इशू हुआ?
शो कॉज नोटिस दिया।
वो किधर है?
वो शो कॉज नोटिस
पेज 74 पे, 74 ऑफ द पिटीशन।
ये जनाब पेज
42 पर रिप्रोड्यूस भी हुआ है,
पेज 74 पर है
इसका। ये तो वेरेस अच्छा नाउ यू आर ये पेज 75 पे आ जाइए ना, ये है ना,
ये है जी पेज 75 पर। नाउ योर लॉर्डशिप आर हियर बाय कॉल्ड अपॉन टू एक्सप्लेन योर कंडक्ट विद रिगार्ड टू द फॉलोइंग एलिगेशंस व्हिच प्राइमा फेसी कॉन्स्टिट्यूट मिसकंडक्ट ऑन योर पार्ट विद इन द मीनिंग ऑफ पैराग्राफ बी ऑफ क्लॉज 5 एंड क्लॉज 6 ऑफ आर्टिकल 209 ऑफ द कॉन्स्टिट्यूशन। You were, while addressing the District Bar Association Rawalpindi on 21/7/2018, have leveled the following serious allegations pertaining to superior judiciary and a state institution.
देखिए इधर तो क्वेश्चन ऑफ सीकिंग पब्लिसिटी नहीं एलिगेशन है,
ये नहीं है।
ये तो एलिगेशन वही है ना, सब्सटेंस पे जा रहे हैं स्टेटमेंट। इट्स नॉट अच्छा
मेकिंग ए स्पीच एंड ऑन द कंटेंट ऑफ द स्पीच एक्चुअली।
पढ़ें बाकी पढ़ें।
That ISI is fully involved in manipulation of judicial proceedings, including marking of cases to honorable benches. 2. That ISI personnel approached Chief Justice Islamabad High Court and asked him not to let Mr. Nawaz Sharif and his daughter come out of prison before general elections 2018 and not to include your lordship in the bench. And that Chief Justice Islamabad High Court responded that the bench will be constituted as per their desire. That your lordship claimed to even have knowledge of the person who conveys messages to the Supreme Court, that daily proceedings of accountability court were being reported somewhere, and that your lordship also knows the reason why the administrative control of Islamabad High Court as per statute was removed so that no judge could look into the proceedings, that your lordship was asked to give assurance that your lordship would give decision as per their request, and then references pending against your lordship would be closed. That if your lordship decided cases according to their desire, your lordship would be made Chief Justice Islamabad High Court by September 2018. Upon presentation of the transcript of your speech, Honorable Chief Justice of Pakistan had been pleased to observe that the allegations leveled in the speech had cast aspersion and maligned the superior judiciary of the country and berated its independence. It also implies some other national institutions. And the Honorable Chief Justice of Islamabad High Court was asked to comment upon the veracity of the allegations leveled against him. He was also asked to obtain from your lordship the material evidence available, if any, to be immediately transmitted to the office of the Chief Justice of Pakistan for consideration and appropriate action if necessary. In response, Honorable Chief Justice Islamabad High Court offered his comments by letter dated 29/7/2018, wherein his lordship responded that while a letter dated 24/7/2018 received from your lordship regarding allegations leveled against Honorable Chief Justice of Islamabad, his lordship has categorically denied all the allegations. The above act on your part amounts to misconduct as envisaged in the provisions inter alia of Article 2, 3, 5 and 9 of the Code of Conduct prescribed by the Supreme Judicial Council. One fact I want to bring to the notice, sir. At the time when these proceedings were initiated, proceedings were going on against Justice Anwar Kansi, Chief Justice of Islamabad High Court, before the Supreme Judicial Council for quite some time. I remember in another case when he sat on the Supreme Judicial Council and I objected. That was a case where I was counsel for Justice Farooq Irfan. I objected to his sitting on the Supreme Judicial Council on the ground that under clause 3 of Article 209, a judge against whom proceedings under Supreme Judicial Council were being
was it the same matter or some other matter?
That was a question. They did not.
साबिक जज इस्लामाबाद हाई कोर्ट शौकत सिद्दीकी बरतरफी केस की समाअत इस वक्त जारी है। सुप्रीम कोर्ट को केस रिमांड बैक करने से आइन नहीं रोकता। वकील वसीम सज्जाद का ऐसा कहना है। वो कहते हैं कि अदालत मुकम्मल इंसाफ के दायरे इख्तियार में भी जा सकती है। अभी लेंगे एक ब्रेक, जिसके बाद हाजिर होते हैं हेडलाइंस।
Suppose the Supreme Judicial Council is convened, legitimately convened to inquire about a judge. It it may be used as a tactical ploy to file complaints against all the members of the Supreme Judicial Council and then say, oh, none of you can hear the matter. So merely that in itself is nothing relevant unless there's a direct nexus. You know, otherwise तो इधर बड़ा खूबसूरत होगा और इनके भी खिलाफ कर दो वो फेल ही हो गया सुप्रीम जुडिशियल काउंसिल.
मैंने ज़िमनन बताई कि उस वक्त ये ऑब्जेक्शन इसलिए लिया गया था कि जस्टिस अनवर कांसी वाज अंडर इंक्वायरी इन अनदर केस अगेंस्ट हिम.
देखिए खान साहब,
आप उसकी आप रिकॉर्ड मंगा लें. खान
साहब सॉरी, या तो आप इसको कोई दलाइल देना कानूनी आईनी, ये मुझे बात समझ नहीं आ रही है भाई. हमें नहीं पता कल कोई 50 कंप्लेंट फाइल कर दे सब जजेस के खिलाफ तो सुप्रीम इदारा ही खत्म हो जाएगा.
नहीं, वो इंक्वायरी वहां होती है जहां सुप्रीम जुडिशियल काउंसिल सेज दैट देयर इज अ प्राइमा फेसी केस for proceeding against him. There was a prima case which was going on, inquiry was going on.
How would that matter to him, to the petitioner?
How it
maybe he gets removed, both get exonerated.
मेरी बात मुकम्मल सुन लीजिएगा फिर उसके बाद.
हाँ बताइए.
हुआ क्या? ये जो फैक्ट्स यहाँ दिए गए हैं कि उनको खत लिखा गया था कि बताएं ये एलिगेशंस हैं, उन्होंने डिनाई किया. What happened? मुझे 11 अक्टूबर को रिमूव किया गया ऑन द रिपोर्ट ऑफ द सुप्रीम जुडिशियल काउंसिल. उसी दिन या उससे अगले दिन उनको एग्जोनरेट कर दिया गया फ्रॉम द चार्जेस ही वाज फेसिंग बिफोर.
तो सीरियस एलिगेशन लगा रहे हैं.
That the very next day, ये facts जनाब आप
I'm saying for the sake of arguments, if these facts are correct, what does it mean?
It means, sir, that वो चूंकि गवाह बन गए हमारे खिलाफ तो उसको उसकी जो एलिगेशन से उसे एग्जम्प्ट कर दिया गया.
नहीं, क्या वही कंप्लेनेंट दोनों केस में था या तो कुछ ऐसा नेक्सस जोड़िए ना.
ये बातें और है, मैं सिर्फ जनाब को बता रहा हूँ देखिए कि सुप्रीम जुडिशियल काउंसिल ने किया क्या. जब उन्होंने मेरी एलिगेशन को डिनाई किया तो उनको छोड़ दिया.
जहाँ तक आपकी बात सब देखिए, हम सुप्रीम जुडिशियल काउंसिल पे ऐसे उंगलियां नहीं उठाएंगे. जहाँ तक आपने बात की ना इंक्वायरी की, वो तो हमें समझ आ गई ना. आपने एक आईनी बात कर दी, वो समझ आ गई. अब ये हो सकता है नहीं हो सकता, अभी हमें इस मफरूजों में क्यों जाएंगे. नहीं, लेट्स स्टे आइन पे बात करें, क्योंकि अब आप 184(3) में आ रहे हैं. देखिए इसमें 184 का दरवाजा खुलता है, इसमें पब्लिक इंटरेस्ट का एलिमेंट आ जाता है. हर जज की सिक्योरिटी ऑफ टेन्योर एंड इज रिमूवल आई थिंक इज अ मैटर ऑफ पब्लिक इंपॉर्टेंस, इसलिए उसका दरवाजा खुल जाता है. आ गई बात इन्फोर्समेंट ऑफ फंडामेंटल राइट्स, आपने बात कर दी ड्यू प्रोसेस एंड फेयर ट्रायल, ये भी समझ आ गई. मगर अब ये जो बाकी चीजें ये इसमें कुछ समझ नहीं आ रही बात.
इसलिए कि जो
हो सकता है सही भी हो तो सो व्हाट.
ये पोर्शन मैंने पढ़ के आपने कहा तो मैंने पोर्शन पढ़ा.
अच्छा इसको छोड़े, कोई और बात करें.
चलिए तो मैं
नहीं, कोई और बात करें तो बताएं.
मेरी तो गुजारिश सिंपल ये है कि दिस इज अ केस वेयर ए जज हैज बीन रिमूव्ड विदाउट फॉलोइंग द ड्यू प्रोसेस.
We got the point. And we are just saying how to go forward. That's all.
This order has to go. This report has to go. Has to be quashed. So that in the future,
but what about the public interest in the matter? They need to know. So, or they are not entitled to know.
उसके लिए मैंने ऑलरेडी सबमिशन की है कि ये ऑर्डर सेटिसाइड होके इसको जनाब रिमांड कर सकते हैं सुप्रीम जुडिशियल काउंसिल एंड इंक्वायरी इनटू द मैटर. दैट इज द आंसर टू माय माइंड. इफ योर लॉर्डशिप थिंक्स
अगर आप नहीं ठीक है, इफ यू कंक्लूडेड, वी डोंट वांट टू कट यू शॉर्ट, कैन वी मूव ऑन टू सलाउद? आई जस्ट सॉ दैट ही इज इन कराची.
जी ठीक है सर, मेरी सबमिशन ये है कि रिमूवल विदाउट इंक्वायरी इज अनकॉन्स्टिट्यूशनल एंड ऑट टू बी स्क्वैश्ड.
आमिर साहब, आप इस एस्पेक्ट को तो डिनाई नहीं करेंगे कि जस्टिस सिद्दीकी साहब को एम्पल अपॉर्चुनिटी ऑफ हियरिंग दी गई थी, क्योंकि प्रोसीडिंग्स 2 महीने से ज्यादा चली हैं और कम से कम 2 से 3 रिप्लाईज इन्होंने जमा कराई हैं. मैं आपसे पूछ रहा हूँ, हामिद साहब आपसे पूछ रहा हूँ.
जी सर, सॉरी,
मैं ये कह रहा था कि आप इस एस्पेक्ट को तो डिनाई नहीं करेंगे कि जस्टिस सिद्दीकी साहब को एम्पल अपॉर्चुनिटी ऑफ हियरिंग दी गई है, 2 महीने से ज्यादा प्रोसीडिंग्स चली हैं और इन्होंने कम से कम 3 से 4 रिप्लाईज अपनी जमा कराई हैं. लिहाजा ये एस्पेक्ट कहना कि जी इनको अपॉर्चुनिटी ऑफ हियरिंग मिली ही नहीं या इनको टाइम नहीं दिया गया, तो ये तो किसी हद तक के दुरुस्त मालूम नहीं होता रिकॉर्ड से. लेकिन अब प्रोसीडिंग शुरू हुई है 23/8 23/7 को और कंक्लूड कंक्लूड हुई हैं 1 अक्टूबर को, यानी कि तकरीबन 2 महीने से ज्यादा चली हैं प्रोसीडिंग्स। और सुन तो लीजिए, और कम से कम 2 से 3 दफा इनकी रिप्लाईज आई हैं और उनकी रिप्लाईज जितनी भी हैं वो सुप्रीम जुडिशल काउंसिल ने कंसीडर करी हैं और सारी रिप्रोड्यूस की हैं अपने ऑर्डर के अंदर, और उसके बाद फिर इनके खिलाफ ये फैसला दिया गया है कि जनाब ये मिसकंडक्ट के मुर्तकिब थे। इसके बारे में आपका क्या कहना?
जी, मैं ये कहता हूं, उन्होंने एक शोकॉज नोटिस दिया 31/7/2018, उसके जवाब में एक प्रिलिमिनरी मैंने सबमिशन की, क्योंकि 14 दिन दिए गए थे। मैंने कहा मैंने फैक्ट सारे डॉक्यूमेंट्स कलेक्ट करने हैं और मैं एडिट रिप्लाई दूंगा। फिर मैंने एडिट रिप्लाई दी, ये 2 रिप्लाईज मैंने दी है। एक एप्लीकेशन मैंने और दी उसमें, जो रिकॉर्ड पर है पेज 223-24 पे, उसमें मैंने कहा कि इन द फर्स्ट प्लेस addressing a district bar association is not a misconduct within the meaning of Article 209, but if this honorable council thinks that this is a case in which I should be proceeded against, please in that case give a public hearing to us, give it as an open court। मैंने ये एप्लीकेशन दी, जिसको कभी उसके बाद एक इन कैमरा प्रोसीडिंग्स हुई, उसमें भी मैंने ये बात रिपीट की कि अगर जनाब मजीद प्रोसीड करना चाहें, उनको तो प्रिलिमिनरी इंक्वायरी थी, वो कोई फाइनल इंक्वायरी जो है सिटिंग नहीं थी, तो मुझे आप ओपन हेयरिंग दीजिएगा। ये पेज 313 के ऊपर ये मौजूद है मेरी दरखास्त, पेज 313 पर, पेज 313, ये वॉल्यूम 2 होगा जी इसका, इस केस का पेपर बुक 2। इसकी तारीख है 29/9/2018।
पेज क्या बताया था आपने?
The applicant
पेज आप दोबारा
313 सर,
313
application for open hearing guaranteed under the Constitution of the Islamic Republic of Pakistan।
ये इसकी आपकी इस्तदा कौन से पेज पे? इस पे फैसला क्या हुआ?
It is therefore prayed।
इस पे क्या फैसला हुआ
जी?
डिसाइड क्या हुआ? डिसीजन
नहीं, उससे नहीं हुई। I was never given any hearing। इसके बाद the one hearing was in camera।
इसमें इशू तो ये है कि जहाँ तक तकरीर की बात है, आप तकरीर डिनाई नहीं कर रहे हैं, मालूम सिर्फ ये करना है कि ये मिसकॉन्डक्ट में आता है या नहीं, नंबर 1। इसका दूसरा एस्पेक्ट जो है, जो कि बार बार मैं इंसिस्ट कर रहा हूँ, वो ज्यादा इम्पोर्टेंट है कि वो जो एलिगेशन थी उसको मालूम करना चाहिए था दुरुस्त थी या नहीं थी। तो क्या सुप्रीम जुडिशल काउंसिल वो तहकीकात कर सकती है? सपोज अगर आज हम रिमांड भी करते हैं, तो क्या वो तहकीकात वहाँ हो सकती है या इसको कहीं और होना है?
हाँ, बिल्कुल इसमें इंक्वायरी होनी चाहिए थी, बल्कि पहला
कौन करेगा इंक्वायरी?
सुप्रीम जुडिशल काउंसिल को करनी थी ना।
नहीं, वो दूसरी एलिगेशन की जो इन्होंने एलिगेशन लगाई, उसके बारे में क्या कहते हैं?
तो एलिगेशन ये
जो कह रहे हैं, जो कोर्ट्स पे जो बाकी रिस्पोंडेंट्स पे जो एलिगेशन लगी है, क्या सुप्रीम जुडिशल काउंसिल उस हद तक तहकीकात कर सकती है?
बिल्कुल कर सकती थी, और बल्कि मैंने ओपन हेयरिंग के लिए कहा था कि आप हमें ओपन हेयरिंग दें।
देखिए, शायद मैं क्लियर नहीं कर रहा हूँ, आप पे ये एलिगेशन तो नहीं है कि आप सही कह रहे हैं या गलत कह रहे हैं। आप पे एलिगेशन ये कि आपने जुडिशरी को मिलाइट किया, जो कि मिसकॉन्डक्ट में आता है।
ठीक,
वो तो आप मान रहे हैं कि तकरीर की सिर्फ ये देखना है कि आपकी तकरीर ज़मरे में आती या नहीं, लेकिन जो एलिगेशन है उसकी तरफ तो किसी ने तवज्जो नहीं दी कि वो एलिगेशन किस हद तक दुरुस्त है, किस हद तक गलत है। उसकी गलत है तो ही शुड फेस द कॉन्सिक्वेंसेस, और अगर दुरुस्त है तो रिस्पॉन्सिबल, लेकिन सवाल ये कि कौन करेगा?
लेकिन उन्होंने इंक्वायरी करनी थी ना इसमें। पहले तो मुझे स्टेटमेंट ऑफ एलिगेशंस देना था कि ये एलिगेशंस हैं इनका, इसको आप मीट करें।
कोई स्टेटमेंट ऑफ एलिगेशन
कुछ नहीं किया गया। सो गुजारिश मेरी,
सुप्रीम जुडिशल काउंसिल वेरी पावरफुल बॉडी। आप जरा 210 भी पढ़ लें आइन का।
ये बिल्कुल सही है कि
ये जरा देखिए, इसकी जरा मैंने अभी इसके जरा अल्फाज का चुनाव जरा देखिए।
Power of council to enforce attendance of persons, yes.
नहीं टेक्स्ट पढ़िए ना।
For the purpose of inquiring into any matter,
not pertaining to, it doesn't connect with the conduct of the judge. अभी I widened up the scope. जरा पढ़े आगे।
सर वो इससे connected
नहीं, जरा चले पढ़ते हैं आगे।
The council shall have the same power as the Supreme Court has to issue directions or orders for securing the attendance of any person or the discovery or production of any document, and any such direction or order shall be enforceable as if it had been issued by the Supreme Court. The provisions of Article 204 shall apply to the content powers. So
it's a very powerful body. It can call anybody.
That is what, in the context of inquiry, naturally, it has to be.
It's not hearing a case. It's inquiry. So वो आपने जो इंक्वायरी कमीशन की बात की, तो ये खुद ही इंक्वायरी कमीशन है इन अ वे।
बिल्कुल
more powerful than इंक्वायरी कंटेम्प्ट के पास भी इनके पास है।
बिल्कुल सही है। मैं इसीलिए कह रहा हूँ, मैं सबमिटेड, the answer is
खान साहब, let me put my anxiety to you. Every Supreme Judicial Council is not the Supreme Court. It's a separate constitutional body. Agreed? Every constitutional body should have maximum autonomy to decide matters. Agreed? Thirdly, we don't want to encroach or say or do anything. It just so happens that I'm a member of the Supreme Judicial Council as well, but we create precedent as well, that it undermines the Supreme Judicial Council. Supreme Court is not a watchdog over. However, like every other constitutional body, when a constitutional provision or a fundamental right is being violated by anybody or not being considered, let's both ways, then the Supreme Court is the only court which has the power, or the High Court, not in this case, to direct that this be done.
Yes.
So we have to be very careful how we proceed in this matter, because it will, like you are citing Justice Clark's case after 50 years, this will become precedent and it will be cited before us maybe earlier than 50 years. So we have to be very careful as to not disturb the perfect balance that the constitution makers have provided in the constitution.
There is an intervening judgment 2018 की, उसमें ये सारे एस्पेक्ट्स बहुत अच्छे डिस्कस हुए हैं, और उसमें ये आया, उसकी हैसियत क्या है ये भी डिस्कस हुई है। मेरी गुजारिश है उस जजमेंट को जरा PLD 2018 सुप्रीम कोर्ट 538, I was counsel that again Shaukat Siddiqui's case.
This is Iftikhar Chaudhry's case.
This is PLD 2018.
वो अच्छा, एक और जो आपका मैटर, नहीं ये नहीं का है, ये तो आप ही का केस है ना?
जी वही। इसमें ये एस्पेक्ट, प्रोसीजर एस्पेक्ट्स बड़े डिटेल में डिस्कस हुए हैं।
Which part you want to read from?
जी अब मैं आपको वो जो है ना बताया कि वो मेरे नोट्स निकाल नहीं, दूसरे वाले नोट्स में
पेज 5559 पे आ जाए।
538 से जनाब
पेज 5559 पे पैराग्राफ 51।
My lord, my lords, am I needed for these proceedings, or can I be excused for now?
Is there something urgent?
Yes, I have. There's a matter which I have to argue, not before.
Okay, fine, ठीक है।
But
कोई बात हुई हमको बता देंगे। But you've noted the points, नहीं?
I have.
ठीक।
Sir, this judgment is very thorough judgment discussing various aspects of Article 209. पहला जो point out करूँगा वो पेज 555 है, पैरा 46। जी, historically Page 555,
historically,
46. Historically, the fundamental rights of the people require protection from the excess of the executive and the vested interests, both commercial and political. In order to safeguard the fundamental rights of the people guaranteed under the Constitution, the independence of judiciary obviously must be insulated from the onslaught of the executive and such vested interests who are past masters at institutional capture. Thus, the security of tenure of judges, more so those of the superior courts, is imperative, and therefore adequate safeguards in this behalf are provided, including by enacting what appears to be a rather cumbersome and strict process of their removal. This cardinal principle is reflected in the constitutional dispensation of all the democratic countries, people by citizens and not subjects. The exception in this behalf are almost always found in...
Fine, you don't need to say this, it's obvious जी.
नहीं सर, एक ये बात जो एक बहुत इम्पोर्टेंट एस्पेक्ट है वो जनाब देखिए पेज 559, ये जरा पैरा 51, ये जरा जरूर देख लीजिए. पेज 559 पैरा 559 पेज पैरा 51. The relevant provisions of the Constitution, more particularly Articles 209, 210 and 211, when examined in the light of the judgment handed down by a larger bench of this court in the case reported as Chief Justice of Pakistan Iftikhar Muhammad Chaudhary, and the previous pronouncements on the subject noted and quoted with approval in the aforesaid judgment, the relevant portions whereof have been reproduced in extenso herein above, should reveal that, firstly, the SJC is a unique forum created by the Constitution. Secondly, the SJC is not a court, though it may exhibit some of its trappings, including the power to punish for contempt. So it is not a court. Yes, year 2010 की judgment भी है. Thirdly, the proceedings before SJC are essentially a fact-finding inquiry, sir. This is what I am submitting here. This is the function of the SJC. Fourthly, the SJC is akin to a domestic forum, and it conducts administrative proceedings regarding the question of conduct or capacity of a judge who is to be judged by his own peers. Fifthly, the findings of SJC are recommendatory in nature and do not enjoy the status.
So, yes, agreed. What is the point you want to make?
I'm trying to make here is a domestic forum. Your Lordship was saying that it's just like as if it is some kind of a rival court to Supreme Court. No. It is a domestic body.
No, it is not. It's a constitutional body.
It's a constitutional body.
So, what happened in this case? Why did you come to court? What relief did you get or not get?
इसका primary function जो है वो inquiry है.
नहीं, ये फैसला जो आप साइड कर रहे हैं, ये क्यों आया आपका केस सुप्रीम कोर्ट में?
ओपन इंक्वायरी.
केस क्यों आप लाए सुप्रीम कोर्ट ये वाला?
ये इसलिए कि हमने कहा था कि इस केस में कि हमारी ओपन इंक्वायरी होनी चाहिए.
तो सुप्रीम कोर्ट ने क्या फैसला किया?
सुप्रीम जुडिशल काउंसिल ने कहा नहीं, इट शुड बी इन फोरम. इस केस में
फिर तो आप ये ग्रीवेंस दोबारा एजिटेट नहीं कर सकते हैं ना हमारे सामने.
नहीं, बात क्या हुई, इसमें उन्होंने अलाउ कर दी ओपन इंक्वायरी. दिस जजमेंट अलाउड ओपन इंक्वायरी subject to certain conditions.
वो पैराग्राफ किधर है?
जी वो उधर भी आ जाएगी. It's a very historic judgment in that केस में
उन्होंने कहते नहीं अलाउ हुई
हैं.
सब SJC
कि क्या फायदे?
वो वापस भेजा ना सुप्रीम जुडिशियल काउंसिल 577 पैरा 96.
वो एक consequently the question regarding the conduct of proceedings.
तो ये तो वो रिमांड हो गया ना. ये केस रिमांड का केस है.
नहीं, इसमें उन्होंने कहा कि
नो हामिद खान साहब
सब्जेक्ट टू सच.
हम जो इतनी देर से आपसे सवाल पूछ रहे हैं, ये पैराग्राफ 96 जो माय लॉर्ड ने पॉइंट आउट किया, पढ़िए.
नहीं वो ठीक है,
आप पढ़िए तो
सर बात ये है,
या पहले पढ़े तो ना 577 पे।
Consequently, the question regarding conduct of proceedings through an open justice as requested by needs to be revisited and decided afresh by SAG, not standing uninfluenced by its order dated so and so, जो order set aside उन्होंने किया।
आप पढ़े ना।
In the light of the observations made herein above, in the light of the observations,
तो this is
observations क्या हैं?
एक सेकेंड जी सर, हमारी बात सुन लेना। अभी हम आपसे बार बार पूछ रहे थे रिमांड, तो ये रिमांड ही तो किया है।
पिछले सवालों का जवाब है
तो ये पहले सवाल का जवाब इधर मिल रहा है।
मैंने भी तो रिमांड ही मांगा है।
नहीं, अगर आपने बताया ही नहीं, आप कोई और वजह से बताया।
जजमेंट का मैं ये कह रहा था कि उसमें
फिर क्या किया सुप्रीम जुडिशियल काउंसिल ने इस ऑर्डर के बाद?
इस ऑर्डर के बाद उन्होंने अलाउ की थी, इन दैट पर्टिकुलर केस अलाउड ओपन हियरिंग।
वो ऑर्डर कहाँ है?
वो कोई दूसरा रेफरेंस था?
वो दूसरा रेफरेंस, वो रेफरेंस 242 है।
अच्छा, ये केस नहीं,
जो इस केस में इम्प्यून था वो रेफरेंस 242।
लेकिन इस रेफरेंस की तो बेसिस जो है वो तकरीर है, और उस तकरीर को आप डिनाई नहीं कर रहे हैं, उसके कंटेंट्स को।
ठीक है, but then that has to be inquired into. तो मेरा गुजारिश ये करनी थी, जो जनाब के ऑब्जर्वेशन थी,
that reference was dismissed. What happened?
That was never decided.
You want that
ये proceedings take off.
You want that be also be decided. आप चाहते हैं कि उसको भी डिसाइड करें?
नहीं सर, बिल्कुल
नहीं, इसकी बात नहीं। मैं तो आपके सामने आपका प्रेसिडेंट दिखा रहा हूँ कि प्रेसिडेंट ये है। फिर उसमें इंक्वायरी का तरीका कार इसमें बड़ा अच्छा तरह डिस्कस हुआ है, वो भी जरा देख लीजिएगा। उसमें उन्होंने कहा कि ये जो इंक्वायरी होगी सुप्रीम जुडिशियल काउंसिल की, उनके ये पैरामीटर्स होंगे। मैं उसकी तरफ जनाब की तवज्जो दिला रहा था। वो तो आखिरी में उन्होंने कहा कि जी ठीक है, रिमांड कर रहे हैं आप, इस जजमेंट की लाइट में आप डिसाइड करें। परफेक्टली ऑल राइट। वो एक पैरा था, मैं कहा था इंक्वायरी में ये कुछ होना चाहिए।
तो खत्म
जी सर। सो मेरी गुजारिश ये है कि all the judgment so far says that a judge cannot be removed on the basis of a report which is not based on inquiry, and this is the case. Without inquiry, the Supreme Judicial Council has submitted a report in which they have recommended the removal of the judge, and therefore that is clearly an unconstitutional void non-est order. About what Lordship was saying, उसके बारे में मेरी गुजारिश ये है कि प्रोसीडिंग्स में शोकॉस नोटिस हुआ एक, उसके 2 दफ़ा, पहला प्रिलिमिनरी रिप्लाई, फिर एडेड रिप्लाई, ये हुआ। उसके बाद एक एप्लीकेशन मैंने दी जिसमें मैंने कहा कि अगर अव्वल तो ये addressing a bar association is not a misconduct, but in case you want to hold inquiry, please hold it in open court. वो जजमेंट वो भी मैंने दिखा दिया। उसके बाद उससे 2 दिन बाद जब हियरिंग हुई, उसमें ये सारे सवाल आए और उसमें हमसे ये पूछा गया कि हाँ इंक्वायरी है, हमने बिल्कुल ये की है, ठीक है।
नहीं, एक सेकेंड। सो देयर वर 2 रेफरेंसेस, एक में अलाउ हो गई आपका ओपन और दूसरे में नहीं अलाउ हुई।
नहीं, दूसरे में तो
आपने कहा था, आपने दरखास्त दी थी ना ओपन के लिए।
सर वो तो ओपन क्वारी का तो प्रेसिडेंट बन चुका था, ओपन क्वारी का तो प्रेसिडेंट हो चुका था।
अभी आपने कुछ देर पहले कहा कि उसमें इंक्वायरी ओपन नहीं हुई थी, मैंने रिक्वेस्ट की थी।
उसमें नहीं हुई,
तो एक में किया और एक में नहीं किया।
इसमें नहीं किया।
और फर्क क्या है दोनों में?
फर्क ये है कि आफ्टर, इसमें तो इंक्वायरी सिरे से नहीं हुई ना, उसमें
नहीं, मैं अब इंक्वायरी की बात नहीं कर रहा हूँ, मैं अब कह रहा हूँ प्रोसीडिंग्स कि वो प्रोसीडिंग्स ओपन करें जी, वो इन कैमरा ना करें। एक में तो आपकी दरखास्त अलाउ हो गई जी, आप कह रहे हैं
बिल्कुल,
वो रेफरेंस नंबर 242 में, मगर इस केस में इसका रेफरेंस नंबर क्या था?
मौजूदा रेफरेंस।
हाँ, इसमें आपने कहा नहीं हुई।
इसमें तो इंक्वायरी नहीं हुई सर।
इंक्वायरी इज अ सेपरेट थिंग। ओपन प्रोसीडिंग्स की बात कर रहा हूँ।
ओपन प्रोसीडिंग्स देखो, ओपन प्रोसीडिंग्स इंक्वायरी की होनी थी ना, इसमें सिरे से इंक्वायरी नहीं हुई।
नहीं, वो एक अलग पॉइंट है। प्रोसीडिंग्स ओपन हुई या नहीं हुई?
एप्लीकेशन पे कोई ऑर्डर नहीं, यानी जितनी प्रोसीडिंग्स।
इसका नंबर क्या है रेफरेंस का, ये वाली मौजूदा का?
347। जितनी
ठीक है, समझ गया।
ओपन नहीं हुई।
So distinguished, got it. खत्म। Can we ask Mr. Salahuddin? We want to wrap it up. Mr. Salahuddin, you've been hearing everything.
I was not able to be to Islamabad because of lack of availability.
What is the way forward? Address that point only.
My lord, my submission is that the report and the notification is to be set aside on the ground of being malafide in law.
Please tell us the way forward.
Yes, sir. My submission is that it cannot be remanded to the SJC. The SJC scope is limited under Article 209. However, this court, if it considers fit, and I would urge that it
who do you represent? Who do you
factual merit.
Take secretary, who do you represent?
My lord, the Bar Association, Karachi Bar Association, and the
So you basically you don't want the truth to come out.
No, sir.
Yes.
In fact, my petition is.
You are saying. Please hear us. You are saying that the relief should be given to the petitioner, but the people of Pakistan should be kept in the dark because they can't handle the truth. So why can't it be remanded? Why are you saying it can't be remanded?
No, not at all, sir. I'm not saying that it should not be investigated. My submission is that the proper forum would either be this court itself or a commission appointed.
We are not seeking your opinion. We are seeking some legal response. In my opinion, that doesn't help us, does it? Why can't it be remanded?
It is because of the language of 209 itself, sir.
Where does it suggest that? In fact, Mr. Hamid Khan has just cited a case where it was remanded, the matter was remanded.
इसमें ये जो केस इन्होंने रेफर किया है इसको डिस्कस करा
I'm not arguing.
15
It cannot be remanded. If Mr. Shaukat Siddiqui was still now.
We can't. Voice is gone.
48.
So the council to recommend his removal. Therefore, it does not have then the jurisdiction under 2096. And so the remand right now cannot be done. It could have been done 2 years ago. But right now, the remedy is that, and certainly those allegations could have been done 2 years ago. But right now, the remedy is that, and certainly those allegations.
So you mean to say, on account, there is a well-settled principle that no one should suffer as a consequence of act of court. So you're saying because the court delayed the matter for 2 years, the petitioner's valuable right has been taken away from him. Is that your argument? We can't hear you. You're not speaking clearly. करें ना ठीक इसको.
That the civil servants actual tenure has ended.
Civil servant को आपने जज बना दिया.
नहीं सर,
अब आप please don't.
Disciplinary proceedings का principle तो वही है सर.
No, it's not. Please, no, don't do this. If you're reducing a constitutional office to the level of a bureaucratic thing and saying the same principle applies, with respect, I will not agree with you.
My submission is that the stigma around the person's reputation caused by wrongful removal, that is something that he is entitled to remove, even if he has finished his age of service. It is the same principle which your lordships entertain appeals against convictions, even when
Mr. Salahuddin, please, Mr. Salahuddin, please focus on the Constitution Mr. Ahmed Khan has read 2095, which says inquiry, then 2096, which talks about inquiry, and you are saying there's no need for an inquiry because he's retired, he's attained age to 62, so even if SJC did not comply with the constitution, so let him suffer.
Yes, sir. What I am saying is this court is to set aside the report of the Supreme Judicial Council and the President's notification on account of being without jurisdiction and then
we are asking you, can it be remanded or not? We're not asking you, can it be set aside?
My solution is the reason the factual allegations cannot be investigated anymore by the Supreme Judicial Council is because
we should. Are you saying that we should take over the functions of the Supreme Judicial Council? That's the only solution. Then there's no other way. Either they do it or we do it.
The Supreme Judicial Council has a specific role when it is different.
Mr. Salahuddin, you're not providing us any solution. You are saying the Supreme Court should assume the functions of the Supreme Judicial Council.
Right, sir. The Supreme Judicial Council will end if a judge, for whatever reason, is no longer there.
Then why are you saying for whatever reason? We are dealing with a real case.
Yes, sir. He has crossed the age of superannuation.
So he should suffer. He should suffer because of that.
No, I'm not saying he should suffer.
I don't know.
I'm saying the order can be set aside
without conducting inquiry. We should set aside the order. Why?
The order should be set aside
without inquiry. No, without inquiry.
Irrespective of the merits of the case, the order is without jurisdiction, therefore it deserves to be set aside. It is without jurisdiction for two reasons. The first reason is that the inquiry was not initiated.
If you are arguing in this manner, what provision of law have you filed your petition under?
184.3.
What's the first word in that? Then you don't have a case. Then we should dismiss your petition on that ground alone, because you're arguing against your own petition now. You are saying you're now claiming the right of an individual and not the public's right. Please read 184.3. It starts with the word public importance. So you are now pleading the case of the petitioner, not the public's. You're not saying exactly what you're doing. You say public should not know the truth of the matter. Please give him his pension and that's it.
So we have two aspects of public importance.
184.3 पढ़िए ना जी.
So the first aspect of public importance is that whether the SJC has the legal right to remove judges without a factual inquiry. That is a question of public importance. The second question of public importance here, which is separate, is whether the allegations of Mr. Shaukat Siddiqui were correct or not. That has to be investigated separately. My only submission is that the SJC no longer can do so. The reason I am saying this is,
you don't. When you say a statement, back it up. That has to be investigated separately. I'm quoting your words. How? That's the only question we're asking you.
Your Lordships, in 184.3, your Lordships can.
I'm just quoting. I'm quoting your words. Who will investigate? We. Say, tell us.
The truth of the allegations can be determined by this court.
So we record evidence. We will record evidence. We will record evidence.
There's no bar to it, sir. But if your Lordships feel that
feel की बात तो नहीं हो रही है. You are assisting the court. We don't go on feelings. Assist the court on the constitutional point, not on our feelings.
My lord, there is no bar under 184.3 to recording of evidence. It is done even in constitutional petitions under Article 199.
ये तो आप हमें वे फॉरवर्ड हम बार-बार पूछ रहे हैं ना, वे फॉरवर्ड बताएं.
गुजारिश ये है कि it may be referred to a commission.
Sir, if you can speak slowly, we can't hear your words.
Mike se thoda piche ho jaye. Mike se thoda piche ho jaye.
My submission is that it may be referred to a commission that inquires into the factual truth or otherwise of his allegations. Because I completely agree that the allegations are of such a nature that the public has a right to know whether they are true or not.
Where does the Supreme Court have this power to appoint a commission?
My lord, the power is 184(3). And
no, don't just say these things. No. Read the language. Where does it say Supreme Court can appoint a commission?
Without prejudice to the provisions of Article 199, the Supreme Court shall, if it considers that a question of public importance with reference to the enforcement of any of the fundamental rights conferred by Chapter 1 of Part 2 is involved, have the power to make an order of the nature mentioned in the said article. Now,
now please stop. Go to 199 and say as that the High Court can constitute a commission. If they can, we can.
My lord,
unless you want us to start writing into words into the Constitution, you can't just throw in something and say commission should be instituted. Commission, the only commission that I'm aware of is Commission of whatever Inquiry Act of 2017,
yes, sir.
Which the federal government constitutes. So where is the power of the Supreme Court to constitute a commission?
My lord, the mandamus would issue to the federal government.
अब आप कहीं और जा रहे हैं तो आपकी प्रेयर में तो ये बातें हैं ही नहीं ना.
What do you say about 210? Article 210. जरा पढ़ें.
For the purpose of inquiring into any matter, the Council shall have the same power as the Supreme Court has to issue directions or orders for securing the attendance of any person or the discovery or production of any document, and any such direction shall be enforceable as if it had been issued by the Supreme Court.
What do you say about when in presence of such a vast powers, why you are reluctant to remand the matter to Supreme Judicial Council?
सर मेरा ये कहना है कि साथ में 209(5) और 209(6) भी देख लिया जाए.
पढ़े?
If on information from any source, the Council or the President is of the opinion that a judge of the Supreme Court or a High Court may be incapable of properly performing the duties of his office by reason of physical or mental incapacity, may have been guilty of misconduct, the President shall direct the Council to, or the Council may, on its own motion, inquire into the matter.
That's the very point we've been saying. Inquire. Admittedly, SJC did not do that. And I'm not following you at all. You're not citing any precedent, or you are just saying, in my opinion, feelings. I mean, let's go on the Constitution. What does it say?
My lord, the Constitution says that the SJC can inquire into the conduct.
That's the whole point. They did not inquire. That's the case. Hamid Khan's case is.
Yes, if I may explain, sir.
It's not an explanation. It's a fact. Either they did or they didn't. They did not inquire.
This is admitted fact.
Sir, if the SJC report and the President notification is set aside, does Mr. Shaukat Siddiqui automatically become a judge of the High Court? No, he does not. And because he does not become a High Court judge, then the SJC cannot inquire.
At least he will get the status of ex-judge of the High Court. Former judge. He will get the status of ex-judge of the High Court.
Exactly, and there is nothing in 2095 that allows the SJC to inquire into the conduct of an ex-judge. Then if your lordship sees 2096 has to be
at that time,
there's a settled principle of law. When a list comes before a court, it has to be decided at what was there at that time. Not aaj law ye ho gaya. Suppose a crime is created today, we will not decide it as today. We will decide it when the law was at that particular time. It's well settled principle. Unless specific retrospectivity is is given to something. So merely saying these things, we can simply avoid what you are saying, that the list before the SJC, we are considering matters, we're going back, traveling back in time. Whether time is moved forward or not, whether he's attained the age of 65, 62, are all subsequent events, coincidental events, which one view is they are very material, that the minute the watch goes forward, 62 is struck out of court. I gave an example, you were not listening maybe, that if before he could file a petition, the next day he retired. So he has no remedy, then you can say, yes, he has no remedy. Let's at least be on the same line. I mean, then I can appreciate it if you use the same logic. But you're simply saying because he's retired, that's it. So then he's condemned. You can drag on proceedings, you can curtail a proceeding.
That is the opposite of what I am saying. I am saying that if a person retires...
But we are not talking about if a person, we're talking about a judge. This is not a bureaucrat here before us. Let's use the word judge.
Right. If a judge retires, and your lordship comes to the conclusion that the SJC order was without jurisdiction.
We are not saying that. No, we are not saying that at all. You've not been following. We are simply focusing on one point and one point alone. No inquiry was held. Without jurisdiction, we are certainly not saying, yes, Supreme Court had jurisdiction.
My humble submission is that factual, the lack of a factual inquiry renders those proceedings forum non juris and without jurisdiction. If there are factual aspects that have to be looked at into, and the domestic forum or the SJC doesn't look into it, then that renders the decision of that forum without jurisdiction and malafide in law.
This you are arguing on the basis of a normal petitioner. Then why should we entertain your 184(3) petition? Where is the element of public interest? We will concern ourselves with the petitioner, the judge before us. You have got no concern with the matter then. If this is your argument, if you merely want him, whatever, that the order set aside, how does it benefit or not? Or how does it, for independence of judiciary, transparency, right of information of the public, then you've removed the entire public importance aspect of the case from your case. Then we should not hear you, we should dismiss your petition, we should just hear Mr. Hamid Khan. If you're taking away you're removing all the public element from it.
साबिक जज इस्लामाबाद हाईकोर्ट शौकत सिद्दीकी बरतरफी केस की समाअत इस वक्त जारी है। जस्टिस हसन अजहर रिजवी ने यह इस्तफसार किया कि आपके खिलाफ रेफरेंस की बुनियाद तकरीर है, आप इस तकरीर के मतन से इनकार नहीं कर रहे। चीफ जस्टिस ने रिमार्क्स दिए कि सुप्रीम जुडिशल काउंसिल एक मजबूत आईनी बॉडी है। एक और अहम खबर आपको दे, बल्दियाती वीकेंड बोर्ड्स के तरक्याती फंड्स मुंजमद कर दिए गए हैं। इलेक्शन कमीशन तमाम तरक्याती फंड्स इंतखाबात मुकम्मल होने तक मुंजमद रहेंगे, ऐसा इलेक्शन कमीशन की जानिब से मौक़िफ़ सामने आया है। बल्दियाती इदारे सिर्फ रोजमर्रा के उमूर निपटाएंगे, बल्दियाती इदारे इलेक्शन तक सिर्फ सफाई सुथराई का काम ही करेंगे। बल्दियाती इदारे कोई भी नई स्कीम या इसका टेंडर जारी नहीं कर सकते। इलेक्शन कमीशन ने जो नोटिफिकेशन जारी किया है उसके मुताबिक बल्दियाती इदारों के तरक्याती फंड्स पर पाबंदी इलेक्शन की वजह से लगाई गई है। इंतहाई अहम खबर, इलेक्शन कमीशन की जानिब से नोटिफिकेशन जारी किया गया जिसमें यह लिखा गया है कि तमाम तरक्याती फंड्स जो हैं वो इंतखाबात मुकम्मल होने तक मुंजमद रहेंगे। बल्दियाती इदारे सिर्फ रोजमर्रा के उमूर सर अंजाम दे सकेंगे। बल्दियाती इदारे इलेक्शन तक सफाई सुथराई का काम ही करेंगे। बल्दियाती इदारे कोई भी नई स्कीम या इसका टेंडर जारी नहीं कर सकते। बल्दियाती इदारों के तरक्याती फंड्स पर पाबंदी इलेक्शन की वजह से लगाई गई है। एक और अहम खबर है, तोशाखाना और 190 मिलियन पाउंड रेफरेंसेस का जेल ट्रायल कलअदम करार देने की दरख्वास्तों पर समाअत। बानिया पीटीआई ने जेल ट्रायल के नोटिफिकेशंस के खिलाफ दरख्वास्तें दायर कर रखी हैं। इसी नौयत के केस पर जस्टिस मियां गुल हसन औरंगजेब ने फैसला दे रखा है। वकील शुएब शाहीन का ऐसा मौक़िफ़ सामने आया है, इसी पर बात करेंगे। अपने नुमाइंदे शहजाद अली ने हमें ज्वाइन किया है। शहजाद, बताएगा इससे मुताल्लिक।
جی محک اسلام آباد ہائی کورٹ میں توشہ خانہ اور 190 ملین پاؤنڈ ریفرنسز کا جیل ٹرائل قلم قرار دینے کے حوالے سے جو پی ٹی آئی کی لیگل ٹیم نے درخواستیں دائر کی تھی، ان پر اسلام آباد ہائی کورٹ کا ڈویژن بینچ چیف جسٹس عامر فاروق اور جسٹس طارق محمود جاگیری پر مشتمل 2 رکنی بینچ سماعت کر رہا ہے۔ بانی پی ٹی آئی نے جیل ٹرائل کے نوٹیفکیشن کے خلاف درخواستیں جو دائر کی تھی، اس میں شعیب شاہین جو ان کے وکیل ہیں، انہوں نے یہ بتایا عدالت کو کہ اسی نوعیت کا ایک کیس پر جسٹس میاں گل حسن اورنگزیب فیصلہ دے چکے ہیں، مناسب ہوگا کہ یہ کیس بھی جسٹس میاں گل حسن اورنگزیب کی عدالت کو منتقل کیا جائے۔ شعیب شاہین جو وکیل ہیں بانی پی ٹی آئی چیئرمین کے، انہوں نے یہ بھی استدعا کی کہ دونوں مقدمات کے ٹرائل کا حکم امتناع جاری کر دیا جائے، اور اس وقت جو ہے وہ اسلام آباد ہائی کورٹ کا 2 رکنی بینچ چیف جسٹس عامر فاروق کی سربراہی میں اس معاملے کی سماعت کر رہا ہے۔ چیف جسٹس نے یہ ریمارک کی ہے کہ جیل ٹرائل ان کیمرہ ٹرائل نہیں ہوتا، صرف وہ پیرامیٹرز دیکھنے ہیں کہ جیل ٹرائل کا طریقہ کار کو فالو کیا گیا ہے یا نہیں۔ چیف جسٹس نے یہ بھی سوال اٹھایا کہ یہ نیب کیس ہے، ہم نے دیکھنا ہے کہ کیا نیب لا میں کچھ الگ ہے۔ اٹارنی جنرل کو آنے کی مہلت دیتے ہیں، اٹارنی جنرل جو ہے وہ اس وقت عدالت میں پہنچ چکے ہیں، اور اٹارنی جنرل جو ہے وہ وفاق کا جو موقف ہے وہ عدالت کے سامنے پیش کر رہے ہیں۔ اٹارنی جنرل منصور عوان اور ایڈیشنل اٹارنی جنرل منور اقبال دگل جو ہے وہ بینچ کے سامنے پیش ہوئے، اور اٹارنی جنرل نے عدالت کو یہ بتایا ہے کہ یہ کیس اس سے مختلف
ٹھیک ہے شہزاد، آپ کا بہت شکریہ۔ ایک اور اہم خبر ہے، سلمان اکرم راجہ نے خود کو آزاد امیدوار قرار دینے کا الیکشن کمیشن کا اقدام لاہور ہائی کورٹ میں چیلنج کر دیا ہے۔ درخواست میں یہ موقف اختیار کیا گیا ہے کہ انٹرا پارٹی الیکشن نہ کرنے پر انتخابی نشان واپس لیا گیا، الیکشن کمیشن نے آزاد امیدوار کیوں ڈکلیئر کیا، یہ ان کی جانب سے سوال اٹھایا گیا ہے۔ اہم خبر جس سے متعلق آپ کو اپڈیٹ کریں، سلمان اکرم راجہ نے آزاد امیدوار قرار دینے کا اقدام چیلنج کر دیا ہے۔ سلمان اکرم راجہ نے لاہور ہائی کورٹ میں درخواست دائر کر دی ہے۔ درخواست میں الیکشن کمیشن سمیت دیگر کو فریق بنایا گیا ہے۔ تحریک انصاف بطور سیاسی جماعت رجسٹرڈ ہے۔ درخواست میں یہ موقف اپنایا گیا ہے، آزاد امیدوار عدالت آزاد امیدوار ڈکلیئر کرنے کا اقدام کالعدم قرار دے، اس کی استدعا کی گئی ہے۔ آئی ایم ایف کا کرپشن اور منی لانڈرنگ روکنے کے لیے ادارے مضبوط بنانے پر زور، حکومت نے اینٹی کرپشن اداروں میں سیاسی مداخلت ختم کرنے کا یقین دلا دیا۔ مزید بات کریں گے، سما کے نمائندے شکیل احمد نے ہمیں جوائن کیا ہے۔ ابھی آپ کو بتا رہے ہیں کہ آئی ایم ایف کا کرپشن منی لانڈرنگ روکنے کے لیے ادارے مضبوط بنانے پر زور۔ شکیل سے مزید بات کرتے ہیں۔ جی شکیل، بتائیے گا۔
دیکھیے، آئی ایم ایف نے حکومت سے مطالبہ کیا تھا کہ کرپشن، منی لانڈرنگ اور اس کے علاوہ جو رشوت ستانی ہے اس کو روکنے کے لیے اقدامات کیے جائیں، اداروں کو مضبوط بنایا جائے۔ تو حکومت نے آئی ایم ایف کو ایک پلان کے بارے میں آگاہ کیا ہے، جس میں کہا گیا ہے کہ نیب سے اینٹی کرپشن اداروں میں سیاسی مداخلت ختم کی جائے گی، کابینہ کی منظوری سے اینٹی کرپشن فریم ورک میں بہتری کے لیے رپورٹ شائع کی جائے گی، اور ساتھ ساتھ رشوت، فراڈ اور بتہ خوری کی روک تھام کے لیے اداروں کو مضبوط بنایا جائے گا۔ اور اس کے علاوہ یہ بھی کہا گیا ہے کہ کرپشن کی نشاندہی اداروں کو شفاف اور مؤثر بنانے کے لیے اصلاحات کی جائیں گی۔
بتانا چاہ رہے کہ ہم انکوائری کر لی ہے، ان کا کہنے کا یہ مقصد ہے کہ انکوائری ہو چکی ہے، ہم نے اپنا پروسیجر اڈاپٹ کر لیا۔ آپ سے ایک سوال، آپ کی بات اگر تسلیم کی جائے کہ ان کے حد تک سیٹسفائڈ کر دیں، ان کا سٹیٹس بحال ہو جائے گا، اور دوسری پورشن میں جو انکوائری آپ کہتے ہیں وہ علیحدہ سے کنڈکٹ ہو۔ سپوز ہم آپ کی بات مان لیں، انکوائری کنڈکٹ ہوتی ہے، اس انکوائری میں یہ ہم ہی کرتے ہیں اور یہ ثابت ہوتا ہے کہ ان کی ایلیگیشن غلط تھی، پھر کیا ہوگا؟ ان کا سٹیٹس واپس لیا جائے گا؟ کون لے گا؟
صرف اس میں پھر یہ ہوگا کہ there would be it would be go then before the relevant criminal court perhaps, because there would be a question of perjury, there would be a question of
ex-judge of the High Court will face the criminal charge without the intervention of the Supreme Judicial Council.
My lord, judges are not above the law.
No, the Supreme Judicial Council, they have to face the consequences through the Supreme Judicial Council.
My lord, with respect, if someone commits the act of criminal defamation,
no, we don't want these analogies which are not applicable to Supreme Judicial Council or to judges. Let's stay focused on the Supreme Judicial Council, on judges and the Constitution. We don't need any analogies. If you can throw any further light, please continue.
No. My lord, I'm not making an analogy with respect, because
please let it go. If you want to contribute, we don't want these analogies.
My lord, this is what is the statement. If the statements are false, then it's not a matter of analogy, then there are consequences for false statements on both sides.
I don't. If I was to deconstruct what you're saying, first of all, it's a never-ending thing ever. let's take logically what you're saying, as what my lord had put to you, that if the petitioners this order is set aside on the basis that no inquiry was held, and subsequently a commission, okay, it's magically formed, we go along with that, and the commission, where is the commission? It's not a court of law, it's not a constitutional body, it's a sub-statute body, naturally, or a body created by an order of a court. It can either be one or the other, not a third one. That finding will prevail over the Supreme Judicial Council, will prevail over the Supreme Court, and on the basis of this inquiry is held, either pursuant to order of the court or the Supreme Judicial Council, a judge can go to jail for perjury. This is the sum total of the argument. I don't follow this.
Let me explain myself, sir. It will not, obviously, the report of the commission too does not automatically affect.
First tell us who creates this commission.
It is formed under the Commissions of Inquiry Act, and if your lordship sees in the act,
if a commission of inquiry determines something that this judge had not stated the truth earlier, he will be persecuted for perjury.
My lord, it prepares a report. That report is then forwarded to the relevant body.
भैया आप ये बार-बार ये चीजें कह रहे हैं ना, vagueness, relevant body. We are a highest court. We want to know what is this body. Each word you must.
Criminal investigation agency, sir.
So we are then handing over the fate of judges to some SHO or sub-inspector in police.
If a judge makes a false allegation, he defames someone, commits libel, and it is found to be false, then he should not expect to.
So Aziz Sahib not quite getting traction with me, at least.
209 के अलावा
कोई और बात करें, या if you want to file, refer to. You are not sorry, but you're not referring to any precedent, any law, any. I mean, these are just opinions stated at the bar. कुछ और हमें बताए ना, कुछ चीज तो बताए ना, कुछ आगे बढ़ने वाली बात.
अगर आप इजाजत दें तो मैं थोड़ा सा ये जो पैसेज
आप ऐसा करें, आप अपना राइटिंग में सबमिशंस कर दें, बिकॉज हमें समझ नहीं आ रही बात, एंड वी आर मे बी यू हैव गॉट बेटर आइडियाज, यू कैन पुट देम इन राइटिंग एंड वी विल कंसीडर देम.
May I just summarize the...
No, please do so. Please do so in writing, because you will carefully think out everything, and I'm sure it will be, because it's also 10 minutes to 2. आप हमें writing में दे दें. We will certainly consider it. Huh?
जरा आर्टिकल 2095 मैं पढ़ना चाहता हूँ. ये कह रहा है कि इफ ऑन इंफॉर्मेशन फ्रॉम एनी सोर्स द काउंसिल और द प्रेसिडेंट इज ऑफ द ओपिनियन that a judge of the Supreme Court or of a High Court may be incapable of properly performing the duties of his office by reason of physical or mental incapacity or may have been guilty of misconduct. यानी कि 2095 का A या B दोनों में से कोई एक भी अगर अप्लाई करेगा तो 209 अप्लाई कर जाएगा. यानी कि लफ्ज इन्होंने और इस्तेमाल किया है लॉ मेकर्स ने. बात हुई इंक्वायरी के हवाले से, तो बड़ी बात हुई और हमने नोट भी करी, लेकिन मिसकंडक्ट के हवाले से कोई एक बात भी कोर्ट में नहीं की गई. टॉकिंग फॉर माई सेल्फ, ठीक है. तो मिसकंडक्ट के हवाले से अगर देखा जाए तो ये जज साहब जो थे जिन्होंने के जो बातें तकरीर में करी हैं, डोंट यू थिंक दैट दिस फॉल्स अंडर द एम्बिट ऑफ मिसकंडक्ट एज पर आर्टिकल 2 जो कि कहता है कि केयरफुल टू प्रेजेंट डिग्निटी ऑफ द कोर्ट, और आर्टिकल 9 जो कि ये कहता है कि ही शुड वर्क फॉर द इंटेग्रिटी ऑफ द इंस्टीट्यूशन ऑफ जस्टिस. नाउ व्हाट आर द इंस्टीट्यूशन ऑफ जस्टिस? इंस्टीट्यूशन ऑफ जस्टिस आर हाई कोर्ट्स एंड द सुप्रीम कोर्ट्स. तो इन दो आर्टिकल्स के हिसाब से आपका क्या ख्याल है कि ये जो पिटिशनर साहब हैं ये मिसकंडक्ट के जुमरे में नहीं आते हैं? अगर थोड़ी देर के लिए हम मान भी लें कि इंक्वायरी वाला एस्पेक्ट जो है वो रह गया था सुप्रीम जुडिशियल काउंसिल से, लेकिन ये जो एस्पेक्ट मिसकंडक्ट का है वो स्क्वायरली अप्लाई नहीं करता है क्या पिटिशनर के केस के अंदर, स्पेशली इफ व्यूड अंडर आर्टिकल 2 एंड आर्टिकल 9 ऑफ दीज रूल्स। तो इस एस्पेक्ट के ऊपर हमें कोई असिस्टेंस नहीं मिली है माजरत के साथ। इंक्वायरी के हवाले से तो जरूर हमें मिली है कि ये इंक्वायरी नहीं हुई और इन लोगों को बुलाया नहीं गया, लेकिन वी हैव नॉट बीन प्रॉपर्ली असिस्टेड, टॉकिंग फॉर माई सेल्फ, विद रिगार्ड टू द एस्पेक्ट ऑफ मिसकंडक्ट जो कि आर्टिकल 209 के बी के अंदर फॉल करता है और जो कि साफ साफ कहता है कि अगर मिसकंडक्ट होगा तो आर्टिकल 209 लगेगा। इसके बारे में आपका क्या कहना है सलाउद्दीन साहब?
मैं जरा ऐड कर दूं माय लॉर्ड की बातों में जी, क्या जो तकरीर की थी वो मिसकंडक्ट में आती थी? यस, उसके लिए इंक्वायरी जरूरी थी? यस
सर, मेरी दो सबमिशंस होंगी इसमें। फर्स्ट ऑफ ऑल, if what he said in his speech was factually incorrect, then it was misconduct. If it was not factually incorrect, if he had correctly stated the facts, then it was not misconduct, number one. Number two, sir, the other reason why it was necessary to assess whether the allegations were true or untrue was because it would affect the proportionality issue. If, for example, all these allegations were correct and the only grievance was कि ये आपने public speech में नहीं बातें करनी थी, तो then perhaps the SJC, the proper course for the SJC would not to be to remove the judge altogether. The punishment also has to meet the crime and doctrine of proportionality. जनाब ने अपनी कई judgments में
नहीं भाई इसराउद्दीन साहब, I understood your first point. As far as your second point is concerned, there is no other option. ये तो नहीं है कि इस साल इंक्रीमेंट नहीं मिलेगी या दो withholding pays हो जाएंगी. Either you remove a judge or you don't remove a judge. Full stop. There is no proportionality involved in 209 at all. I don't know where you're getting this proportionality element and introducing it into the SJC. Rap on the knuckles, be a good boy, don't do it again. You know, that they can't do. Either they dismiss the complaint or they sustain the complaint and give a finding of misconduct and recommend his removal. That's all. Where's proportionality? Where are you getting this from in 209?
My lord, the court can certainly not give a lesser punishment. Your lordship is absolutely right. It's not a court,
it's Supreme Judicial Council we're talking about.
Yes, sorry, the Supreme Judicial Council, sir. The SJC cannot give a lesser punishment, and your lordship is absolutely right. The question is whether the misconduct complained of is serious enough to justify removal. Your lordship will appreciate that the code of conduct says, for example, that a judge should not be rough in his conduct. Complaints are made against judges that they are rough in their conduct. On those complaints, the SJC would not be justified in actually removing a judge for misconduct because such a penalty would be disproportionate to the complaint made. Because if your lordship sees the code of conduct,
you then agree. You agree with us, not then, okay, we got it.
जी सर। अब सर एक और
जी
जो फैक्ट है
no, wait, that offer of filing something you're not availing, you want to conclude, it's up to you.
Sir, there's just one point that I would ask that your lordship hear me on. It'll take 2 minutes, sir. It'll take 2 minutes. If your lordship just sees the order, the report of the SJC, I page 8. Page 39. Ji sir. Your lordship sees that the first note is set up is sent by the secretary of the SJC.
Have you seen that already, Ji?
He is the complainant. Number 2 में अगर आप देखें sir, the chairman of the council passes an order that the Chief Justice of the Islamabad High Court may comment upon veracity of allegations.
Mr. Khan has already referred to it. Ji,
sir. Isme, sir, the chairman of the SJC has directly started the inquiry
without assigning the
order.
Without assigning matter to the other.
ये अगर आप प्रोसीजर भी देखें रूल्स 4 to 9 and of course 209 का 5 and 6 article 209 का 5 and 6 the SJC chairman has no role to play in terms of starting the inquiry has to be started by the Supreme Judicial Council. What is calling for a report from the Chief Justice of the Islamabad High Court and for evidence from Mr. Shaukat Siddiqui, that itself was the inquiry. That is an act fully without jurisdiction, and the entire superstructure based on that falls, sir.
Anything else?
My lord, I'll file my written note, sir.
Okay. Anybody else wants to say anything? We'll wrap it up.
एक चीज मैं जनाब की तवज्जो दिलाना चाहूँगा, particularly his lordship's answer, very specific in this judgment of 2018. Page 569, what are the minimum standards of due process under Article 209? वो चंद लाइनें मैंने पढ़ के सुनानी है आपकी.
Where from? ये
PLD 2018 Supreme Court 538.
अच्छा आप ही का केस जी.
538.
रेलेवेंट बताएं, पेज बताएं. Relevant page.
Relevant at what page you want to read from?
569.
569.
आपके सामने 569
जी.
अब 69 आपके सामने है जी सर. सेकंड लाइन से पढ़ना चाहूँ. There is no serious dispute.
Mike ले लो
जी.
Mike.
जी. There is no serious dispute between the counsel appearing before us in this behalf, as none of them did or could have confessed that the procedure to be adopted by SJC can be unfair or unjust. This is obviously essential in order to ensure security of tenure of the judge, which is, as already stated above, is the primary purpose of Article 209 of the Constitution. The controversy perhaps pertains to the standards of due process which need to be observed and whether the SJC procedure of inquiry 2005, more particularly paragraph 13 thereof, meets such standards. There also appears to be consensus amongst the learned counsel, learned Attorney General for Pakistan and learned amicus curiae that except for the disputed paragraph 13 of the SJC procedure of inquiry 2005 and the remaining procedures compliant with the universally accepted principles of due process, including as reflected in our Constitution and the various pronouncements of this court. Now this is very important. The judge whose conduct or capacity is the subject matter of proceedings under Article 209 of the Constitution is issued a notice informing of the allegation against him. He is afforded a right of hearing. The findings are based on evidence. So this is most important. Based on evidence which are recorded in his presence. He is also afforded the right to cross-examine the witnesses and produce evidence in his defense. He has right to be represented by a counsel of his own choice. These are the basic elements of due process given by this honorable court that SJC has to follow. So there cannot be any finding given by without evidence, and that evidence should be recorded in his presence with an opportunity to cross-examine. None of that has been done in this case. So therefore, mere show cause notice means is neither.
Mr. Hamid Khan, Article 10A has been incorporated in the Constitution, but the principles enunciated in Article 10A have been applied even prior to the incorporation of Article 10A. But now Article 10A is very much part of the Constitution, which has raised it to the level of a fundamental right.
Right.
Due process and fair trial.
That's right.
Now, speaking for myself, the point, I mean, even if you have to remove a Naib Qasid, there is a whole procedure. I mean, that is an employee of the government, not a constitutional office holder. And if surely the requirement should be higher, not lower, than for removing a Naib Qasid. I mean, I would imagine it should be. And if then otherwise, what's the worth of a constitutional office if it's not protected at all? So we have to see the Constitution as a whole. We cannot disregard fundamental rights. We cannot disregard the fact of the absence of an inquiry. If in the absence of an inquiry someone is exonerated is one thing, but if in the absence of an inquiry a person cannot be punished. I mean, I think these are the things which are quite clear and obvious. Now, the problem which is at least agitating my mind, and I want you to submit if you all can do so, is where does the Supreme Court draw its line as the Supreme Court of Pakistan not to encroach upon the domain of the Supreme Judicial Council. The Supreme Judicial Council may do some sort of inquiry. That's not the case before us, whether it was sufficient or insufficient. Here there is no inquiry. No inquiry. Unless the speech is in itself so offensive that it merits immediate removal. That's one aspect. The other is, if we read the show cause notice, is very much premised on institutions' integrity and institutions being maligned. So everything flows from it. You cannot disregard the content of the speech. Now, the content of the speech there can be two things. It could have been misunderstood. That's not the case here. The question is it what the judge is saying correct, or what the judge is saying not correct? You are saying it's correct, they are saying it's not correct. We wanted to hear their point of view. Yes, I did say this, I did meet him, but for a different purpose, whatever. That's not the case. No meeting, I never spoke to you, I never said anything. Now, we can't throw a coin in the air and decide who's right. Nor can we, which brings for you opened the door of 184.3. It's not a civil petition for leave to appear or a civil appeal, where our jurisdiction is wide and we can do whatever we want to. Now, my understanding of 184.3 is two hurdles you have to overcome. Matter of public importance. If you start asserting individual rights, which Mr. Salahuddin I was trying to explain to the point that he's removing himself from the domain of 184.3, otherwise it may be a very good case. So if you come before us under 184.3, then it has to be a matter of public importance. And your rights, you have to link with the fact that removal, if it becomes so easy to remove a judge, then independence of judiciary as a whole is under threat.
Yes.
That's I accept. But if you only say, my removal is wrong, maybe you won't meet the test of 184.3. The next part is for seeking the enforcement of a fundamental right. Now, which is the fundamental right? Article 10A, maybe some other article as well, 25, I don't know, whatever you say. But so that's the thing. Where does the public, once we bring in public interest, public also has a right to know the truth. I mean, it shouldn't be perceived that we protect our own when they don't deserve protection. That's very important. Because this is really in the public domain. So, okay, fine, theek hai. So the public will say, but did he say it or not? Was it true or not? That's the question I was asking Mr. Salahuddin, and he was not coming up with that because he's actually taking his petition out of the domain of Article 184.3. Maybe it's all very new because these questions have just arisen during the course of the hearing. So we've given him time, and we'll also, the last point is, where do we go from here? One is remand. Can we do it or not? He's saying once you retire, it's over. The learned Attorney General has referred to some other case and says till that case is not decided, you should not decide this, or words to this effect. So if you can submit a note on these legal points, we'll reserve it. After, if we require to reconvene again, we will reconvene again. But otherwise, consider this. I mean, if my colleagues agree, for reserving the judgment subject to, we may want to reconvene after the notes come, or we may have more questions. I don't know. So is this clear? I mean, Khwaja Sahab, you agree with this course of action, or you can also submit us a note, because not necessarily, you said you're not invested in the outcome, you're more interested as counsel. Now we're calling upon you, senior counsel. You can assist this court. The same applies to Mr. Wasim Sajjad Sahab. He's also very senior counsel. So he also said, I need time to absorb the matter.
With your Lordship permission, I'll submit a written note on legal issues. That
you may. Yes, please leave the facts aside.
Yes, that is
completely out.
We're not going into
at all. Don't mention anyone. No. Just on these issues. If you can, if you want to, you may. We are not directing you to. No, because you are not a party. Yes, but we felt that things were said behind your back, so you had the right of audience, which we have given you. So, which Hamid Khan Sahab also agreed. आपने पोस्ट नहीं किया था ना इनका नोटिस? इनको इशू करना हमने नोटिस आपने पोस्ट तो नहीं की थी ना? ठीक. तो कितना वक्त आप लोगों को चाहिए होगा to come up with some sort, because this is actually not only this case, every case creates precedent, but in these matters, precedents are very rare. I mean, you know, like very few come, and this point is a novel point, and you said this, it's never happened that no inquiry has been conducted. Now we want to just see whether, I'm not doubting your statement, but Mr. Salahuddin and Mr. Khwaja Haris Sahab may tell us no. There are other cases where also inquiry were not held. We would want to know what is the world practice, whether it can be done without an inquiry of the nature that you are setting. We want to know about freedom of expression, of what judges can and cannot say. Because one is, I mean, even Khwaja Sahab was not very confident on which particular misconduct it is. I mean, publicity, I mean, so that allegation was not leveled. First allegation should have been leveled, you were seeking publicity. So anything else you want to say, please do so. Otherwise, this will be, we'll consider it reserved. ठीक है, लिख लें आज कोई है लिखने वाला ऑर्डर? आप इसमें लिखें.
2 weeks time. Sir, I need only 1 week to have a comprehensive note on.
देखिए आप आजकल जरा बहुत सारे केसेस आ रहे हैं, and all of them require a lot of thinking and detailing. So we'll certainly give you more than a week. I mean, it's not that. इसमें लिखिए. We've heard the notices were issued to General Lieutenant General retired Faiz Hamid and Brigadier retired Irfan Rame, and
he's not retired, my lord. We corrected that. He's still in service.
Okay, and Brigadier Irfan Rame. And is he still a brigadier or is
he's still a brigadier?
And Khwaja and senior counsel Khwaja Haris has entered appearance on their behalf and states that he's filed CMA numbers 267 and 268 of 2024 attending to the allegations leveled against them by the petitioner. So full stop. Learned senior counsel Mr. Wasim Sajjad states that he represents Justice Muhammad Anwar Kasi, former Chief Justice of the Islamabad High Court, and has filed CMA number 253 of 2024 attending to the allegations pertaining to him.
3 CMS filed.
एक से काम नहीं बना वसीम सजाद साहब. चलें वो लिख लीजिए फुल स्टॉप. Notice was also issued to the former Registrar of the Supreme Court of Pakistan, Mr. Arbab Muhammad Arif, who has filed CMA number 270 of 2024. ठीक है, full stop. Next paragraph लिखे. We've heard Mr. Learned Senior Counsel Hamid Khan for the petitioner and Mr. Salahuddin Ahmed for petitioner in CP number. आपकी कौन सी है सलाउद्दीन साहब? हाँ? 15 आपकी CP का नंबर क्या है?
I'm sorry, my lord.
What's your CP number?
15 of 2020, constitutional petition.
15 of 2020.
20.
एक और भी है apparently. And two CP's number 2 and 15 of 2020.
221 की है।
अच्छा 221 की अलग अलग नंबर चेक कीजिएगा प्लीज, ठीक है? Full stop. We've also heard Mr. Learned Senior Counsel Messrs. Wasim Sajjad and Khwaja Haris, और कोई तो नहीं, यही सब हो गए. Full stop. And the Learned Attorney General for Pakistan. Full stop. Assisted by मलिक जावेद असिस्ट किया था या उन्होंने आपको असिस्ट किया? अच्छा, मलिक जावेद. फुल स्टॉप. नंबर ऑफ फुल स्टॉप. असिस्टेंस इसमें लिखिए लीगल लर्नड काउंसिल में सबमिट देयर concise statements. Precise. My lord adds precise and concise. Statements with regard, amongst others, to the following queries which arose during the hearing. Colon. फिर आप इसको 1, 2, 3, 4 कर लें. Whether an inquiry was conducted by the Supreme Judicial Council, and if not, was it a constitutional or legal requirement, and if it was, the consequences of the failure to do so. ठीक है? Question mark. Whether, if the consequence of doing so. Number 2 लिखें. The consequence इसमें लिखते हैं whether that since in the interregnum, that since during the pendency of CP number 76/2018, CP number so and so लिखते हैं was filed on, कौन सी तारीख को फाइल हुई थी? 76
October 2018.
वो डेट ले लीजिएगा. 18 October 2018, and the petitioner attained the age of 62 years
30th of June 2021.
On 30th June 2021, whether what, if any, how can the matter now be attended to if the petition is to be allowed, okay, if he is to be granted, allowed, if he is to be granted relief, whether, including whether the matter can be remanded to the Supreme Judicial Council. Anything else? Whether there was no need to conduct an inquiry by these SJC as the speech admittedly given by the petitioner in itself, making of the speech in itself constituted misconduct as defined in the judges, वो पूरा नाम लिख दीजिए, code of conduct. ठीक है? Anything else you want to add?
Sir, in addition to response to these questions, I may kindly be allowed to give the propositions, my propositions.
हमने लिखा amongst others, वो बाकी आप जो मर्जी लिखना चाहें, मगर ये चीजें अटेंड कर लें. अच्छा, full stop. हाँ, precedents भी दे दीजिएगा. हमें लिखने की जरूरत तो नहीं है ना?
Everything.
ठीक है.
Comprehensive.
So these three you attend to. The rest, whatever you want to add, we are not stopping you. But just keep it sort of more precise. Not, it shouldn't be legal drafting. It should be point.
Thank you.
Chale, thank you very much. It's been a learning experience also for us. जो ख्वाजा साहब, अच्छा हाँ, कितने within how much time to be given आपको?
I think 2 weeks. If your lordship wants.
हाँ,
it's up to
3 हफ्ते दे दें. नहीं, ये legal issues है ना.
Quite right.
You know, we don't want to say something ना. अब इतना वक्त गुजर गया तो 1-2 हफ्ते अगर वो हमारे खान साहब नाराज ना हो कि ये 3 हफ्ते अब दे दिया. ठीक है, खान साहब 3 हफ्ते ठीक है? 3 हफ्ते ठीक है?
सर 2 हफ्ते ही काफी होंगे सर.
तो ख्वाजा साहब 3 मांग रहे हैं, 3 कर लें. वैसे भी ये इलेक्शन वाला हफ्ता तीसरा हो जाएगा ना फिर. ठीक, हाँ, तो ये इलेक्शन के बाद ही जाएगा मेरे ख्याल में. अच्छा, इसमें लिखे कंसाइज स्टेटमेंट्स टू बी फाइल्ड विद इन 3 weeks. In case after judgment is reserved, however, in case after examining the concise statements and the available record, a further hearing is required, the court will convene. We don't know what you're going to say, and some of the things I have not read that were filed today and yesterday. Sure.